generally speaking, those cameras operate kind of isolated from the phone itself. They operate on a system, record video, send it up to a cloud or some form of a server as run by that application provider. Then the phone is simply using an application to access that data.
And a blink camera is like a security camera?
Correct.
Okay. If someone accesses that blink application from their cell phone, is that video or that data placed onto the cell phone somehow?
There is information, yes.
How does that work?
So follow with me, if you will. Most applications, because as humans we generally are impatient, they will try to do their best to help ease user interaction with those specific apps. So taking Blink, for example, when you load up the Blink app on your cell phone, it will load in what we call cache information to your cellular device. It's done by the application, not necessarily by the user. But it's done so that every time you go back into that application, things that were there before are already there and you don't have to wait for it to reload. Think about it if you're looking at Instagram or Facebook, anything you had looked at previously is already there. Next time you go back into it, it just loads the new stuff. It caches all of that data to the phone, and we're able to see that data when we do our forensic extractions.
Slow down a little bit.
Apologize.
When you examined the Blink camera data from the phone, did you locate any camera footage from the nighttime?
No, we did not.
Can you explain why there would not be footage from the nighttime in this situation?
So what we did find in some of these videos is that the cameras themselves were either mounted or placed behind a glass window. At night, these cameras operate off of infrared, so the light turns on, but because the camera's behind a piece of glass, it's actually reflecting the infrared back at the camera itself, so the camera's effectively blind. We did locate a number of videos indicating that was it, and we didn't find any videos from the nighttime itself.
So did you find any Blink videos showing either the shooting or what happened just before because of that very problem?
None that I saw, no.
Did you locate some photos on, or some videos on the cell phone that were taken directly from the cell phone itself?
We did.
Did you also locate evidence on Ms. Lorinz's phone that she had called 911 on 2 separate occasions on June 2nd, 2023?
We did.
As far as the 911 calls, how does a phone store that information?
So generally speaking, phones will store that information in the database itself. Specifically, the database we looked at for this is the call history, specifically the call logs.
Does the phone itself record the exact time that the call is made?
It does.
Does it record the duration of the call?
It does.
And how does it do that?
So generally speaking, it's from the timestamp of the phone itself when the call is made, and then the duration until it is hung up and terminated.
And how do we know that timestamp is accurate?
It's based off of the phone itself, connecting to the cellular provider.
Could the phone have the wrong time on it or something?
It's possible, but generally speaking, with the phones, they actually obtain accurate time from the cellular provider based off of where you're at in the world, so they're generally accurate.
Was a report generated showing these 2 911 calls that occurred on June 2nd of 2023, the dates, the times, and the duration of those calls based on the information you extracted from the defendant's cell phone?
There was a report made, yes.
Was a report generated also showing certain videos captured from her actual cell phone that appeared during your extraction process?
There was.
And did that report show videos taken from her cell phone from about 7:21 and 14 seconds p.m. until about 8:53, 32 seconds p.m. on June 2nd of 2023?
That is correct.
Showing it from Marcus Exhibit X. You recognize that report and the disc that's attached to it?
I do.
How do you recognize it?
Has my initials on both.
Okay. Have you reviewed the report before?
I have.
And does that fairly and accurately depict the information you extracted from the defendant's cell phone?
In reference to these items, yes.
And we mentioned some videos. Have you reviewed the disc that's attached to that exhibit?
That is correct.
What's on that disc?
They are the videos as referenced in the report itself.
Okay. And about how many videos are located on that report?
I believe there's 11.
Does the report show what looks to be like duplicate entries of the same video?
That is correct.
Can you explain to the jury why that would be the case?
So on phones themselves, the operating systems of the phones will move things about and do things to, again, ease user access. We go back to that cache data we were talking about with the Blink application. Specifically, we find the exact same videos in two separate locations on the phone. One within the DCIM folder, stands for Digital Camera Image. It's a general rule of thumb, if you will, when it comes to actually taking photos. The other one we find within a cache folder of the actual file system for the Apple operating system itself. It's the exact same video, just located in two separate places on the phone, so we report in both.
And why do you report them both?
Just so that we can talk about both of them existing.
Okay, and you mentioned the word cache again. What is that?
That's done by the phone and the operating system itself, not necessarily by the user.
This time you're on a state would move state's exhibit X into evidence as 22.
Objection, hearsay, relevance.
Over the objection, given evidence that states number 22.
Thank you, Your Honor. If I could have access to the TV.
You ready to go?
Yes, sir. All right, I'm showing you the first page of that report that we just looked at. Can you just explain to the jury what we're looking at so they'll understand?
Sure. So as you can see at the first line, it's labeled as number 1, and then subsequently after that, you have 1 with a 1 in parentheses, and then a 1 with a 2 in parentheses. That goes back to what I was just talking about the duplicate videos. So it shows one video. It's the exact same video based off of that hash value. Essentially what that is a algorithmic, talk of it as a fingerprint for those specific files. It shows that they're the exact same thing. Underneath that, it shows us the name and location, as well as any metadata associated with the videos as we found them. So that
What's
is for
metadata? Before you go on, what is metadata?
metadata is generally data about data. Think of it as a subset of information about the specific file we're talking about. So in this case, it's the created, modified, and access times, as well as the path and the name for these videos we're looking at. On this screen right here, it's the 2 sets for items number 1 and 2 with their duplicates for the videos we're looking at here.
And what is it meant by created, modified access times?
Judgment approach.
Yes, ma'am. Overrule the objection.
These terms are probably self-explanatory, but what does created mean?
Generally, it's when that video was created on the storage media, in this case, the phone.
What about modified?
When it was last changed or edited.
And what about accessed?
Generally speaking, when it was last viewed or seen.
I want to go through those 11 videos that you extracted from the phone.
Okay.
Did you locate a video on June 2nd, 2023 at 7:21:14 p.m.?
We did. That's the first video.
And are many of these videos very, very short?
That is correct.
Okay. So this first video, according to the report you have, occurred on 7:21 and 14 seconds p.m.
That is correct.
Based on your extracted data from the phone, what time was the first 911 call made on her phone on that day?
Going to that page of the report, the first 911 call was at approximately 8:54:09 p.m. on
How do you
16.
know that these videos were taken directly from her cell phone?
So, again, going back to the specific file path we were talking about, they actually show that they were from the actual phone itself, and there is metadata within the report to show that it was from a specific make and model of the phone to which it lives.
Showing you a photo that you found from at 7:30 and 12 seconds p.m. Was there a photo at 7:30 and 36 seconds p.m. as well?
There is videos.
Is there a photo or a video at 7:58 and 59 seconds p.m.?
There is.
There's nothing to record!
Alright, hey, line up, let's go!
Did you locate a photo at 8:33 and 34 seconds p.m.?
We did.
Did you locate a video at 8:33 and 59 seconds p.m.?
We did.
What about a photo at 8:34 and 57 seconds p.m.? A video, excuse me.
We did.
How about a video at 8:49 and 49 seconds p.m.?
We did.
Was that video only like a second long?
I believe so.
Was there another video 2 seconds later at 8:49 and 51 seconds?
That is correct.
Now, if this video was at 8:59 and 51 seconds, is that about 5 minutes before the first 911 call was made?
That is correct.
Did you locate a video at 8:50 and 37 seconds p.m.?
We did.
And finally, did you locate a video at 8:53 and 32 seconds p.m.?
We did.
Is that last video about 30 seconds before the first 911 call was made?
It appears so, yes, sir.
You mentioned that you also extracted the data regarding the two 911 calls made by the defendant's phone on the evening of June 2nd, 2023, right?
That is correct.
What do we see on this page of the report?
This is specifically those two 911 calls, their timestamps and durations.
And does the report, the extraction data from her phone show the time that the first 911 call was made?
It does.
And what time was it again?
That was timestamped at 8:54:09 p.m. So, yeah, UTC, and it lasted approximately 4 minutes and 55 seconds.
Okay. We see that under the number 1 column.
Correct.
So if that first call was made at 8:54:09 and lasted 4 minutes and 55 seconds, about when would that phone have disconnected?
Approximately 5 minutes after, so roughly 8:59 p.m.
According to your extraction results, when was the second 911 call made?
That was made at 9:01 and 37 seconds p.m.
So about how long between when the first 911 call was hung up and the second call was made?
Approximately 2 minutes, 30 seconds.
Thank you, sir. No other questions, Your Honor.
Cross-examination? Is he excused?
He is, Your Honor.
Sir, you're excused. Thank you and have a nice day.
Thank you, Your Honor. Mr. Buxman?
Evidence back?
Thank you. State rest, Your Honor.
All right. Ladies and gentlemen, the state of Florida has rested its case. However, the trial is not over. I'm going to have you go back to the jury room, and we'll go over a few things here, and then we'll see who the next witness is going to be. Right now, go back with leave your notepads here, and go back with the bailiff, and we'll have you out as soon as we can, okay? All right, so the state has rested its case. Jurors are outside the courtroom.
Your Honor, I'm doing the motion for judgment of acquittal.
Either way you want.
May I approach?
Yes, ma'am.
Your reference. Your Honor, at this time, the defense moves for a judgment of acquittal, based on the evidence that's presented in the light most favorable to the state. The state has failed to satisfy its burden in this case. The case law is clear that once a prima facie showing of self-defense is made, that the state has the burden of disproving that she acted in self-defense, that Ms. Lorincz acted in self-defense, beyond a reasonable doubt. So the evidence today has failed to meet that burden. The state's evidence showed that there had been prior violence from Ms. Owens. There was a battery where she threw a sign. There were prior trespasses. There were prior threats. Those came from multiple state witnesses, including, I guess, through the officer from Ms. Owens herself. The confrontation on June 2nd was started by Ms. Owens approaching Ms. Lorinc's residence. There's also evidence of Ms. Lorinc's attempts at disengaging, both in the past and on June 2nd, by telling her, "Get off my property," trespassing, and attempting to use other means to get this confrontation stopped. It's also supported by the evidence afterwards that she surrendered to Deputy Stringer and to Trainee Barboza, that she called 911, and that she gave full statements to law enforcement and follow-ups at the detective's requests. And I present to the court some case law on the matter. Jenkins v. State, 942 Southern 2nd, 910. It's a Florida 2nd DCA case from 2006. The facts in that case are a little bit different. Other than the banging on the door, it's also a case where the victim was banging on the door. In that case, the defendant actually had two residences, two mobile homes that were next to each other, and the victim was banging on the door to the residence that the defendant did not live in but was owned by him. And in that case, the court denied the motion for judgment of acquittal, and
Well, in that case, it looks like wasn't there like some sort of punch thrown?
yes,
Like the victim actually punched the defendant first?
yes, that's correct. The facts
Okay.
are somewhat different from this case, and he was not inside the residence at the time, and they do go through that. The reason that I cited that case is it also has a nice recap of a lot of the Florida cases regarding self-defense, starting on page 6. It talks about 7 Florida cases that have reversed convictions based on the state's failure to rebut a prima facie case of self-defense, and then goes through kind of the facts of each of those, that in a circumstance where, I think they're talking about all these cases here. Thompson, which talks about a case where there's a fight where the defendant has backed up, brandished a gun at an aggressor, but the aggressor continued to approach, that kind of scenario. So it does a good job at kind of explaining the circumstances under which the state has or has not rebutted cases of self-defense. And then it also talks about circumstances where the courts have properly denied a motion for judgment of acquittal. So refusing to acquit defendants based on claims of self-defense are materially distinguished in certain scenarios, like when a defendant's brother threatened to kill him during an argument, then the defendant drove away and returned later with a rifle. That was distinguished. In those kinds of cases, the courts have properly denied a motion for judgment of acquittal.
Okay.
Additionally, I provided to the court SR v. State 11 Southern 3rd 442. It's a third DCA case from 2009. This is not a this is a self-defense case, but it is not a deadly force case. This is a juvenile case where the evidence in that case was that the juvenile defendant, who I believe was a female, was in a circumstance where she was in a hallway, and her stepfather, who had prior acts of violence, was blocking her exit, and she kind of pushed past him on her way to the door, and the court found her guilty of a battery, and the appellate court reversed and said that self-defense does not focus on whether an act was purposeful, it's whether or not an act was done to defend oneself against the imminent use of force. And in that case, similar to this case, there was testimony of prior acts of violence, and there was testimony that she was aware of those, prior acts of violence. And so the court found that the denial for judgment of acquittal was unreasonable, and they reversed. And then the last case that I cited is McGriff v. State. This is an older case. It's 341 Southern 2nd, 1036. It's a 4th DCA case from 1977. The reason that I wanted to bring that case to the court's attention is that in that case, they talk about the circumstance where the behavior of the defendant after the shooting happened, in this case, also tends to support the claim of self-defense, which is like the case here. In that case, I guess the victim was intoxicated. The defendant initially pulled out a gun and fired a warning shot, and the victim continued to approach, and there ended up being a scuffle, and the gun discharged, and subsequent to that, the defendant ordered that someone take him to the hospital, and then the defendant turned himself in, and he gave a full statement to law enforcement. So for those reasons, I would ask that the court grant the defense motion for judgment of acquittal.
What's the state's position?
In the instant case, the state has established a prima facie case to go to the jury established the Owens manslaughter. We've established that the crime happened in Marion County, that the victim, Ms. Owens, by stipulation, was in fact the victim in this case. She's deceased. We've established that she is deceased because the defendant, by her own admissions, fired the gun through the door. The projectile struck the victim, and the victim died as a result of that. That her own testimony shows an intentional act was committed by pulling the trigger. There's no indication it was accidental or something to that effect. Additionally, based on the facts and circumstances of this case, we've established that the decision to fire that firearm would constitute culpable negligence. As far as the self-defense aspect goes, Your Honor, the defense has provided, I believe, 3 cases, all of which are very factually distinguishable from the instant case. Here, the instant case, we have the defendant behind a closed, locked, deadbolted door, and we have verbal statements by the victim and some hounding. Clearly, a reasonable jury could find that there is no imminent threat towards the defendant at the time that she chose to shoot the gun, and as well as there is no imminent ability or attempt for the victim to engage in a forcible felony. Even if this court assumes she was trespassing as not a forcible felony, it would justify the use of deadly force. I ask the JOA be denied.
All right, well, I've listened to the evidence quite carefully and taken notes, especially on issues I thought would be relevant to the defense and to what I understood would eventually be a motion for judgment of acquittal. I do find that the evidence, when viewed in the light most favorable to the state, which is the proper standard at this point in the trial, that the state was able to present competent, substantial evidence that could overcome Ms. Lawrence's self-defense claim, and also produce competent, substantial evidence which would support a verdict for manslaughter. So I will deny the defense's motion for judgment of acquittal, and we will move on from there.
Yes, sir.
I know you have at least some witnesses or witness available today? Okay,
We have 1 witness here.
all right.
Your Honor, before we go any further, the defense, before the last witness testified, may have said enough to trigger an allegation of a discovery violation by report. I'm not sure if they're still pursuing that, considering that we did send them the report well before the witness testified. I'm concerned that if there is an allegation of discovery violation, an appellate court may look at that. There was no Richardson hearing conducted.
Judge, no, the defense, just so it's clear for the record, the defense did receive both reports from Mr. Buxton. The defense's only concern was the fact that they had not listed Jesse Eubanks as an expert witness, and then we're trying to tender him as an expert witness, just so that's clear for the record, and I think that issue was resolved.
So you're not suggesting there's a discovery violation?
No,
Thank you, Your Honor.
You're not requesting any sort of any sort of Richardson hearing?
no, sir.
I do find there was no discovery violation. The state provided the extraction reports, which is essentially what Mr. Eubanks testified to. Ultimately, he was not qualified as an expert for any sort of analysis. I think digital forensic technicians are maybe a little different than other types of experts anyways, because typically Mr. Eubanks would be simply reading from an extraction report in this sort of case, and then showing what was on the phone, which is a little different than most sort of experts. But ultimately, no one tried to qualify him as an expert. The defense has said there's no discovery violation. I find there's no discovery violation. Therefore, I find there's no reason to conduct a Richardson hearing, and we'll move on with the trial.
Thank you, Your Honor.
But you just have one person here, is that correct?
Yes, sir.
That's fine. I'll let the jury know they'll come early, and we'll go from there, okay? I do want to go over some, after that, once the jury's excused, see if we can get as close as possible to getting the instructions done. Is that good for everybody? I think
Yes,
I have the last instruction. I would request, there is another instruction that can be read subsequent to jury verdicts, regarding that jurors have a right to not talk to the press. I don't know the number of it. It's somewhere in the instructions. I do think that may be appropriate to read in this case.
Yes, sir.
Standard instruction?
It's in the standard instructions, I believe.
We'll find it.
No idea what number it is. I can probably look later on this evening, but it just informs jurors that it's their right to not comment on the case. Yeah, I think it informs them they have a right to comment on the case, but they have a right not to comment. And that may be appropriate in this case.
Yes, sir.
So it's read only after a verdict comes, regardless of what the verdict is. So it's not read to them prior to making a verdict, okay?
Yes, sir.
If you can't find it, I'll find it. I've seen it before. But I don't have all the numbers memorized, as you might guess. All right, so let me go down. And any changes that we make to jury instructions, just send me the instructions that are final. I don't need all the other ones again. Like whoever sent me the last packet sent me all the preliminaries and everything else.
That was me.
Huh?
That was me.
I wasn't blaming anybody. I threw it out there as a whoever, so you know, if you want to confess, fine with me. But it's just I don't want to keep throwing away pieces of paper.
Yes, sir.
You know, pile of unnecessary paperwork. We'll bring the jurors back in, and then we'll excuse them after the witness. Welcome back, ladies and gentlemen. As I said, the state has rested their case. The defense has one witness they want to call. After that witness, we're going to take a recess for the day. You'll get to go home early. And then I'll see you same time, same place tomorrow, okay? Go ahead.
The next part is Rosalie Smith.
What's the first name?
Rosalie.
Rosalie?
Yes, sir.
If you could raise your right hand for me.
Sorry.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Have a seat, ma'am. Thank you very much.
Good afternoon.
Hi,
Can you please introduce yourself for the jury?
Rosalie Smith
Ms. Smith, where do you currently live?
at 1724 Southwest 107th Lane.
You live in apartment 2?
Yes, ma'am.
Is that here in Ocala?
Yes, ma'am.
Is that where you were living back in June of 2023?
Yes, ma'am.
How long have you lived out there?
Since sorry.
That's okay.
Since December of 2021.
Did you move here from California?
Yes, ma'am.
Is that where you were born and raised?
Yeah.
Where was the last place that you lived in California?
Roseville.
The neighborhood that you live in now, can you describe it for me?
Your Honor, may we approach?
Sure. Ladies and gentlemen, I'm gonna have you step out just for a little bit again, sorry. All right, the jury is outside the courtroom. I'll have a proffer of her testimony.
Sure. I'll do the proper first and then.
Sure.
The neighborhood that you live in now, can you describe it for me?
It's, I don't know, it's less than mid, it's a little bit above the hood. How's that?
Have you described it as one step away or a step away from the hood?
Yes.
Okay. And Judge, there's been several witnesses so far that have testified to this. I think Ms. Costa may have said that as well, and I think one of the deputies, I think it was Deputy Stringer, had testified that the neighborhood was troublesome. It kind of goes to Ms. Lawrence's state of mind, so I think that this testimony is relevant.
What's the state's position on that?
Again, I would object with her characterizing the neighborhood as one step away from the hood. One, I don't believe that's relevant to the issue of self-defense between the issues of the victim and the defendant. Two, I believe any type of characterization like that is more prejudice than it is probative of anything. And I think I know also in her deposition she talks about, gunshots in the neighborhood and things like that. And I just think this is an improper characterization of the neighborhood. That's,
I'm
again,
gonna have the witness.
prejudicial approach.
Is that the only question you're gonna ask her in those regards?
Yes, sir.
Okay, I'll have the witness step outside the courtroom for just a little bit. Referring to someplace as troubled, I mean, lots of places can be troubled. Referring to someplace as a hood clearly has kind of a racial connotation to it. So I don't mind her saying, it's lower economic, it's just a financial term, or that's been troubled, but referring to something as a hood, I think has.
You said lower economic or what? You kind of broke up.
I mean, I guess I don't have a problem saying something like, and I don't want to put words in her mouth, so you may have to find another word for her besides hood. But I would say, it's obviously not a financially wealthy area. It's pretty clear that these are a set of quadruplexes, which typically, at least in this part of Marion County, are not, terribly expensive. Most of them are rental properties. But referring to something as a hood, now I think you're trying to refer to as some sort of racial context or for lack of a better word, some sort of black neighborhood. That's the clear connotation that I think I would draw from that. And to that extent, I think it's too prejudicial and has no probative value.
I understand.
Because we already have in evidence that is and I don't know what the situation is regarding anyone else who lived there, but we know that at least this defendant rented there. Sounds like maybe she rents there, so it's a rental community of quadruplexes. So I think it's pretty clear that it's already, not the most wealthy part of the county. But I'm not gonna allow her to refer to something as a hood.
I understand the court's ruling, just for the
Okay.
record, I'm not introducing it for that purpose any way whatsoever. I'm mainly using it to show that this was kind of an unsafe or bad neighborhood. I understand that that's what the court's ruling, I just want to put that on the record, that that's not my intention. I can speak with her.
Yeah, I think you need to find some word other than hood, because then you have suggesting that it's bad because there are African Americans living there, and that's the connotation that comes from that, versus bad because there's people of any race that may do something wrong.
So is the
You
court
know.
okay with her saying that it's sort of a lower income neighborhood?
Sure, I think that's pretty much already in evidence, like I said, most of the quadruplexes I've seen in Marion County are just like this. They're mostly rentals, and, you know, people are living there for periods of time, but most of them aren't owned by, I guess they could be, but I don't think most of them are owned by the people who live there. But they, I mean, some could be, but even that, it's not, like I said, it's not like you're living in a mansion, so I think, you know, yeah, sure.
I don't know if Mr. Smith or whoever's seeing this wants to go with me when I'm speaking with her, because technically she's on the same.
Yeah, I mean, I you know, I think that's, you're interjecting something that doesn't need to be interjected in trial.
Gotta love the appellate lawyer.
Ready for her to return? Ready for her to come back?
Yes, sir.
Bring her back, then we'll bring the jurors. Ready for the jurors? Let's bring them back. Welcome back, ladies and gentlemen. Ready to proceed? Thank you.
The neighborhood that you live in now, is that kind of like a lower income neighborhood?
Yes, ma'am.
Now, how far away is your house from Susan Lorinc's house?
I describe it about a football field.
Almost a football field away?
Yes.
Have you ever met Susan Lorincz?
No, ma'am.
Did you know Ajike Owens at all?
No.
Did you ever meet any of the people that were involved in this incident?
No, ma'am.
So I want to talk to you about June 2nd, 2023, okay?
Okay.
Where were you when the shooting happened?
I was sitting on an enclosed patio at my apartment.
Was that like a little patio behind like a wooden fence?
Yeah. Probably a 6-foot fence.
What did you hear?
I heard a lot of pounding, a lot of yelling, screaming, and then I heard a gunshot.
Did you hear a lot of pounding on a door like it was going to be pushed down?
Yes.
Did you call it like a cop knock?
That's what I call it.
Was it very loud?
Very loud.
Did you hear anyone screaming?
Yes, I heard a woman's voice screaming. To me, it sounded like she was screaming words, but I could not understand any of the words.
Was there a lot of pounding on the door?
Yeah,
And you said you couldn't make out what the person was screaming.
absolutely not.
Was it a female voice screaming?
Yes,
Was the female screaming at the top of her lungs?
probably.
Was it like a pound, 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 let me in kind of thing?
Yeah,
Your Honor, and I would object to the question as a mischaracterization of the witness's earlier testimony
So ruled.
and speculation.
Did it sound like the woman was really angry?
I would say so, just by hearing her voice.
Now, could you see any of this?
No, ma'am.
So even though you were almost a football field away, you could still hear this?
I could hear it.
How long do you think the pounding went on for?
It seemed like it went on forever. Maybe 5 minutes, maybe less, but I mean, I wasn't timing it, but it just went on and on and on.
Thank you. I have no further questions.
Cross-examination.
Yes, Your Honor. So Ms. Smith, how are you doing today?
I'd rather not be here, but I'm great.
Can I ask you a couple of questions? One, you said you were in a patio. Were you outside?
I was outside my apartment, yes.
Is there any type of roof or anything above your patio?
No, there's no roof,
Okay.
just a fence.
So you're outside, and defense counsel asked you a question about it was pound, 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 and did it sound like a let me in? But you testified you didn't hear any specific words, correct?
And none of them,
Yeah. You couldn't make out any words that were said.
no.
So any idea of what might have been said would be purely guessing on your part,
Absolutely,
pure speculation on your part.
yes,
And you called 911 in this case, correct?
yes,
And you only called 911 after you heard the loud sound, correct?
yes,
All right, and you believe that loud sound to be a gunshot?
yes, I know what it sounds like,
Okay, and it was only after you heard the gunshot that you called 911?
right.
Thank you, no further questions.
Any redirect?
No, sir.
She excused?
Yes, Your Honor.
Ma'am, you're excused with our thanks. Have a nice day.
Thank you.
All right, ladies and gentlemen, we're going to be done for today. I remind you to put your notebooks down. I also remind you that, the case is not over, so you can't begin to deliberate in any way. We are in recess, so you can, of course, go home or wherever else you want to go. Remember my prior warnings about looking up anything. Please don't look on local news sites or local television where it may be covered. Please don't talk to anyone about the case or let anyone talk to you about the case, okay? If anyone does try to say anything to you, please let us know, and we'll be happy to take care of that for you. Have a very nice day. Thank you. All right. The jury has been excused for today. So, does everyone have a copy of the jury instructions?
Yes, sir.
Yes, sir.
Yes, Judge.
The one besides where you sent to me, is that the same one the state sent, or is that a different one? Or
No, it's the same, there was just some grammatical errors that I found, so
Okay.
the state asked me to fix them, and I did, and I sent them.
Okay, no problem. I'll read it again. I mean, there's always little grammatical errors. Ironically, some of the grammatical errors are in the standard instructions. I don't know why they don't ever fix them. But nevertheless. Okay. Let me know when you guys are ready. Have you, whoever has saved this copy probably needs to follow on the computer so you can send it to me.
I'm doing it, Your Honor.
Yeah, I got it.
Okay.
But do you have the copy that, because you fixed errors, did you send those to him?
I have Ms. Sizemore's copy
Fixed.
open on my computer to edit.
Nothing, if you want to clear a room, just mention jury instructions and man, you will clear a room. I feel like that's the way they should, deal with riots. We're gonna start reading jury instructions. Well, I can't take that. So, okay. Obviously, we'll read, we'll start with 3.1. Then we'll go to 3.2. Next is 7.1, Introduction to Homicide. I normally don't read the title to that. It just seems like an odd title, Introduction to Homicide. Right. And normally I mean, I don't mind having, I don't, I mean, I don't mind leaving it there. I'm just saying, I don't usually read it out loud because it's kind of weird
I'll take it out, Judge.
sounding. If you just want to put,
I'll just take it out.
yeah. Feel like an introductory course that, you know,
Law school.
taught to first year law students or something like that. Has everyone looked at 7.1 though?
Yes, sir.
Yes,
Okay.
Judge.
I mean, leave in the title is justifiable and excusable homicide. Leave that in.
Yes, sir.
Does anyone have any objection to anything on 7.1?
There you are.
Then we have 7.7 manslaughter. Have you all looked at 7.7?
Yes, sir.
All right.
Yes, Judge.
Is there any objection to 7.7?
There you are.
3.3A, aggravation of felony by using a firearm. Any objection to that?
No, sir.
Okay. I would just point out that although I think probably people would assume that manslaughter is a firearm, you are identifying the offense as a firearm. But otherwise I'll read it unless someone else huh? It says aggravation of felony by using a firearm.
I mean, I can take that heading out so they're not confused. That's
I mean,
just,
normally we don't identify crimes as either felony or misdemeanor.
True.
Although probably people will maybe come to the conclusion that manslaughter is a felony. But if you want me to take it out,
Yeah, we can take out the heading.
I'll
you
take
can
it
just,
out.
you can just put the word offense there. Aggravation of offense by using a firearm? Or
Okay.
aggravation of crime,
Yeah.
whatever you want to put it.
I'll put aggravation of an offense by using a firearm.
Okay. All right. Otherwise, that's fine. 3.6F, justifiable use or threatened use of deadly force. Have you all looked at that instruction?
Yes, sir, it's pretty, I think it's almost exactly like the one that I proposed and sent to the state. They just added in a language about the burglary stuff,
Okay.
which I'm not objecting to that.
Yes, Judge.
I'm just reading it as we go along here. The only thing is, do you want to clean up paragraph A because there's no allegation that she was in and was being removed? It would make the sentence a little less cumbersome.
We can do that. We can probably clean it up after.
And say, the person against whom the defensive force was used was in the process of unlawfully and forcibly entering a dwelling, residence, or occupied vehicle.
We can take out occupied vehicle.
Yeah, you don't really need occupied vehicle. You can say dwelling or residence.
Okay.
I'd like to add or keep in or had unlawfully and forcibly entered dwelling or residence, and we can leave it like that.
Okay, let me. All right, so you want to say the person against whom the defensive force was used was in the process of unlawfully and forcibly entering, or had unlawfully and forcibly entered a dwelling or residence. Because we don't need occupied vehicle, we don't need or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle. I mean, do you want me to take out that kind of like last part about?
Yeah, just end it at, or residence, period.
Okay, so we don't need.
Well, it would be a
Or,
semicolon.
yeah, semicolon, yeah.
So it would read, the person against whom the defensive force was used was in the process of unlawfully and forcibly entering, or had unlawfully and forcibly entered a dwelling or residence.
Semicolon.
I guess you get rid of the comma after dwelling and just put or residence. Because we're taking out the part that says, or if that person had removed or was attempting to remove another against that person's will from the dwelling. So you want that last part out?
Yes, sir.
Okay.
So just to clarify, paragraph A is going to read, the person against whom the defensive force was used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling or residence, semicolon. Okay, that's all I'll leave it
I mean, I'm trying to read it. Is there some, I'm just kind of thinking as I'm talking to you. We know the person hadn't removed, but do you want to leave in, or was attempting to remove another against that person's will? This idea,
Yeah, probably would be better.
okay. So,
So, dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling.
Dwelling or residence.
Okay.
Or was attempting to remove.
Yeah, I just took out had.
yeah, it just gets cumbersome when you say that person had removed. Okay, so we'll say, I think it will read like this. The person against whom the defensive force was used was in the process of unlawfully and forcibly entering, or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling or residence.
Got it.
It's a kind of a cumbersome, I don't know what they mean by that person. Talking about the person with the gun or the shooting victim, when you say that person.
Is that the person who the force was used upon?
then, I mean, there's no allegation that the person upon whom the force was used was attempting to remove another against that person's will. Is that a situation where like someone's trying to kidnap somebody out?
Correct. So the person who was.
In that case, we wouldn't need it in this case.
I think only testimony was beating on the door and saying, "Come outside."
Yeah, I guess my only concern is just that testimony about like come outside and her pounding on the door and trying to get in. I don't know if that could be construed as like that she was trying to attempt to get her to come out. I don't know, Judge. I don't want to waive any arguments in that regard, but I understand the court's position on that.
I mean, I don't think the case is gonna turn on that. I mean, I'll leave in anything you want me to leave in.
Yes, sir.
So, it will read like this. The person against whom the defensive force was used was in the process of unlawfully and forcibly entering, or had unlawfully and forcibly entered a dwelling or residence, or if that person was attempting to remove another against that person's will from the dwelling or residence. Is that good?
Yes.
So all we're really taking out is occupied vehicle, which doesn't apply, or had removed, which never happened.
Yes.
Okay, good enough. And then between A and B, there's an and, right? So they need both A and B?
Yes, sir.
Okay. And just so we're clear, I don't want to mispronounce, is it Ajike, right? Ajike?
Well, some people say.
I feel like I
Some
feel
people
like I
say
probably
Ajike.
mispronounced it at some point. It's not
According
the
to her-
easiest name to pronounce, and I apologize, but
According to her mother, right?
It's what?
Ajike.
Yeah.
Ajike? I've tried to spell it out here phonetically, it's Ajike. But I don't want to, and I apologize if I mispronounced it. It's not the easiest thing to pronounce, unfortunately.
Ajike.
Okay. That's why my parents named me Bob. Everyone got that one right. Nevertheless, Ajike. Okay. Okay, so that finishes off that. 3.7, plea of not guilty, reasonable doubt, and burden of proof. I assume you want that one?
Yes, sir.
You know, I just was reading about a case where somewhere they didn't read that. I don't know if it was a Florida case or somewhere else, and they said, no, that's you really can't. It's you know,
That's an unskippable one.
it's an unskippable one, yeah. But I think the defense had agreed to it, but nevertheless, no. Or they all just forgot to read it.
They better have their strategy argument prepared
Yeah,
from
yeah.
now on.
So this is the most recent one, right? So they've added the sentence, proof beyond a reasonable doubt does not mean proof beyond all doubt.
Right.
Yes, Judge.
Okay. I know you've taken off the paragraph regarding the defendant become a witness in this case, is that correct?
No, that's not in,
Is that down further?
that's in the weighing the evidence.
Okay, yeah. 3.9. Any of those 10 that you want out?
That I want out,
Right, or don't think apply?
yeah.
I don't think 10 applies.
10 could come out, 9 could come out, 7 could probably come out.
Does the state agree to these 3 out?
10, 9,
7,
and 7, yes, we agree.
is that it? So,
6.
8 will become 7, 9 will, it'll simply, well, 8 will become 7, that will be it.
Yes.
We'll read the first 6, and then 8 will become 7. Okay. Okay. So we have the paragraph on the defendant becoming a witness in this case. Ms. Lawrence, I want you to understand 2 things, and I'll give you an opportunity to think this over overnight. You have a right to testify in this case. If you choose to testify, the jury will be instructed not to hold that against you in any way. Excuse me. The jury will be instructed to consider your testimony like that of any other witness. Do you understand? So if you testify, I will read an instruction saying the jury will consider your testimony like that of any other witness. Do you understand that?
Yes.
Okay. You also have a right not to testify. If you choose not to testify, then the jury will be instructed not to hold that against you in any way. You have both of those rights. However, they're opposites, so you can only exercise one of them. You must choose to either testify or not testify. I do want you to discuss this with your attorneys. However, the choice is yours. Please don't let anyone make that choice for you. I would like for you to listen to their advice, but remember the choice is yours. Do you understand that?
Yes.
And do you understand that you can change your mind up until your attorneys rest the case? So even if you say you want to do one thing, you can change your mind and then choose to do another. Once your attorneys rest the case and we begin to instruct the jury, well then it's too late after that to change your mind. Okay? All right. So I want you to discuss that with them. If they force you to make a choice one way or another, please let me know and I'll correct that because the choice is yours, okay?
Okay, great.
All right. So we'll address that when it comes down to it, whatever choice you make. All right? All right, so 3.9A, that will be the one that will be given if she chooses not to testify. 3.9B, do you want the one regarding defendant statements in here?
Yes, sir.
Okay. Three point 10, rules for deliberation.
Objection.
Cautionary instruction,
Objection.
verdict.
No objection. No objection to the verdict.
Okay. All right. So, and then you have 3.13.
And 4.2 is the instruction about the media.
Okay.
I'll put that. I'll put that in after 3.13.
Okay. So normally what I would do is read the first part of the instructions, and then I'll read the charges. Is there, I guess there's no lesser included offenses?
No, sir.
You're not requesting any lesser included offenses?
No, sir.
Okay. I'll read the charges, and then I'll read the aggravation of felony by using a firearm, and then I'll read justifiable use of deadly force, and then plea of not guilty, reasonable doubt, and burden of proof, and then I'll break. Okay?
We need do we have 2.7 in there?
What is it?
The closing argument instruction? I don't remember seeing that.
No, we didn't have that. We need that.
I'll add that.
2.7,
I'll put that in after the aggravation of a
right.
gun.
The other part, I mean, and I'll leave this to the defense, would you rather I read justifiable use of deadly force first or reasonable doubt first? Makes no difference to me.
Reasonable doubt first.
Okay. Remind me when we go over it again, we'll just flip, because I think numerically they're the other way, but I'll be happy to read reasonable doubt first.
Yes.
Okay. Just remind me, because I'll probably forget.
Yes, sir.
And then the second part is mostly regarding how they deliberate and all the rest of that stuff. So, okay.
Yes.
So you have some witnesses tomorrow, and we'll be here for that. Just so I get an idea of the schedule, if we rest tomorrow, do you, and you're early enough, do you guys want to go into closing arguments then?
I mean, it doesn't really matter, I guess, it depends on the time.
Okay.
Just
Who's doing closing arguments?
I am, Your Honor.
I am Judge.
Okay.
I anticipated, I mean, for me, maybe an hour and a half, 2 hours at the most, so I don't know.
I'm not gonna limit you, I just, whatever you tell me is reasonable, I'm happy with that.
So that's the only thing about, I don't know what time will be done, so I don't know if we want to just plan on doing Friday morning, it doesn't really matter.
I mean, if we give me some time frame, so you may take an hour and a half, 2 hours.
What about you, Mr. Johnson?
Probably an hour, Judge.
Okay.
I know they have 3 experts they're calling, so, right?
Yes.
Those are, so you have a max of possibly 4 witnesses.
Correct, so we just want to make the decision that we will plan on doing closings Friday morning?
No, I mean, I'm gonna see how far it takes us.
Sure.
I mean, if we're good on instructions and depending how long it takes you to get through experts, if I feel like we can get it done today with, enough time, to deliberate, I'm not gonna send them out at 4:40 or anything like that, but, then I'm
Yes,
good
I'll
with
be
it.
prepared to go either way.
Okay, all right.
And just, do you want a 2.7 closing argument after aggravation of the firearm, or were you wanting to read justifiable use of?
I usually read it at the end of whatever the last part I'm reading in the whatever the last instruction from the first part, because it kind of leads you into now they are going to do their closing arguments.
Okay.
I know it's like usually actually I usually like the first word, like the first sentence is always the state and defense have now rested their case.
Yeah.
So I usually say that, read the first part of the instructions, then the rest of the paragraph I read at the end of it, because it explains that you're going to do these closing arguments and how they're broken up, and that, people are not supposed to take those as facts and that sort of thing. If you put it in there, I'll get it in the right spot.
Okay. But you're going to read, before we make closing arguments, you're going to read, obviously, the manslaughter instruction, the aggravation of firearm.
Yeah, I'm gonna read 3.1, 3.2, introduction, all that stuff, manslaughter, charges, aggravation, reasonable doubt, justifiable use of deadly force, and then do your closings.
Okay.
Kind of break it down between charges, because I feel like they need to kind of know what to look for when they're listening.
Okay.
The rest of the part describes how they deliberate,
All right.
so they don't need that until they actually deliberate.
So I'll put it after justifiable use of deadly force.
Yeah. All right. That's it.
Thank you, Judge.
See y'all tomorrow.
Thank you, Your Honor.
spoke.
I don't know that.
Well, then ask him to come speak.
Yeah.
And
He's
help
supposed
us
to
to
be
be
up here
up
and no, he can't. You are not a spokesperson.
Yeah,
you are not bigger
he's
person to
what
talk.
he's missing
You
out.
have
You know
authority
what
to
he's
talk.
missing us is?
All in here. No, you cannot be a spokesperson.
I see
Let
everybody
him talk.
say that it's not because you or everybody else got Mamta. This is not fair.
Hey everyone. Hey.
I can talk.
Oh, let's for everyone who's here right now, let's take a quick break. Let's cool down. No one benefits from conflict, especially public conflict on camera. For everyone here. This is one focus. Not to blame on anyone, and at the same time to very much support someone. Everyone, let's come together so she comes home. That's the bottom line, okay? Everyone cool? All right, thank you. And for press who's here today, I know they want to wrap up, so we can do that now. There were about 80 some odd folks who were here today, and if everyone in the 80 agrees on one thing, it's that Mamta needs to come home now.
That's it.
So thank y'all.
And thank you all the press for coming in. Thank you everybody for coming in today. Thank you everybody who coordinated this platform. Thank you so much. Yes.
No, I think we're gonna wait.
We're done.
We wait.
No, done.
We're gonna wait.
Can you guys sit over there and take a quick picture, please? Thank you so much. Thank you for doing that.
Can I ask you something?
Test.
I work with them. They are my family. There needs to be white people, brown people, any people looking for Mamta. And relying solely on this Nepali community is not fair because they don't use their big voice. So I hope someone in the media will say, we don't care what color your skin is, help us.
Lead at 4, so I hope I get some point across.
I hope you can really say that because when all you see is an audience of brown people, people don't pay attention, right? If it was a white girl, it would be different. So please say, I don't care what color your skin is, you can't help us. We love you.
How do you allow entry? How do you know her? Are you friends?
Yeah, we used to work together.
Okay. I'm trying to explain who's in the crowd.
Yeah, she and I used to work together.
So friends, some friends.
There's a lot of nurses here.
It seems like a lot of nurses, family friends, that
Yeah,
sort of thing.
but
Okay.
I'm here because I used to work with
I
her.
think it also speaks volumes that people who like the award try to speak to her. Yeah.
I'm very privileged that I know her.
Yeah. Okay. Okay. So what do you actually do a live interview? Probably, but.
I don't know.
If they're still here at 5, I might suggest that. Like, yep.
Or maybe they already have the information and they don't want to share it. But we need
For this, probably.
nothing, zero.
Okay. If they're still here, I'm gonna move out of the way a little. Okay, I'm gonna move out of the way, and then you can show them. Yeah.
So how long have you been doing this? Oh my God, since after the 6th day we found that out and we started saying, why was this not that was my first question. And he's saying that he has to do it, but they have to handle it. And then the police have to do their part, remember this, 48 hours. That's why it's supposed to be I was being very proactive and this is why I asked, if you have it on a database. So that's why I called. You don't even know the FBI. No. They're not involved yet, so they need to get involved now. I need to know. And that was my concern. So I called the WTOP, you name it, every platform, so that this is a mass community. And we are a small community, right? We have a united community, right?
They said we're after weather.
You might not speak against this like I do, but don't push them away.
So for 5, I'm gonna use that coworker, and I got her name, and I already picked the husband. Yeah, it's gonna be very like SOT VO SOT. We'll just throw it into your laptop though.
I don't know.
Have you had any communication with her?
I did. I had. And she's saying that because she's not texting way. So can you come to Yeah. So this time she
You know what? Should I used to ask her to do a live interview? Yeah. And well, no, I was gonna say save the 4 o'clock script for the 5. I don't know if it's too late for them to change them.
It's the better
Yeah. It's supposed to be a spoker, right? Spoker, it's not there.